And we are recording currently.
It looks good.
How many people do we have? Do we have any?
I can see 15 participants.
Yep.
Cool.
16 now.
Okay. So should we begin?
Let's do it.
All right. Good morning, everybody. My name is Dulcie O'Sullivan. I am the lead for Renting in Seattle, which is part of the Seattle Department of Construction and Inspections. And this is the first of two home fairs that Seattle Department of Construction and Inspections is hosting for the public. There's one today, obviously, and then there's one in February. And what we're planning to do today is to just go through sort of the top 10 most important things to know about renting in Seattle. It's a fairly broad presentation, and that is because we're going to have people coming in and coming out. And so hopefully you will be able to garner some nugget that is useful in this presentation. So we have about 2 hours. The questions, you can ask questions throughout. There'll be somebody monitoring the chat function to answer questions. And then we'll have a little bit of time at the end for questions as well. So today I'm joined by my colleague from the Seattle Office for Civil Rights, David Edwards, and he is a civil rights analyst or investigator, and he will be here to talk about some fair housing laws and to answer any questions that fall under those regulations. And also with me is Maureen Rote, who supervises the Property Owner and Tenant Assistance Group for the Department of Construction and Inspection. And she is a font of wisdom and knowledge. And she is also the person who has kindly volunteered to manage the technical aspects of things today. And as we have experienced in previous Zoom meetings and webinars, we do come across some technical challenges sometimes. So just please bear with us if that happens. Just hang in there, and we'll do the best we can to overcome and move forward. So Maureen has some housekeeping stuff to share with you, and then we'll move forward with the presentation.
Okay, thank you, Daisy. Just a few quick announcements. If you are joining us, please turn off your video so that we can save some bandwidth. Also, if you require closed captioning, you can go to the left-hand side of your screen at the bottom and click on the closed captioning option. We ask that you stay muted when you're not speaking to reduce background noise, and put any questions that you have in the chat. We will do our best to get to all of the questions that come in. If we don't answer a question right away, just know that we may be holding off because we're going to get to it in the slides that are coming up, but we will do our best to answer those as we go along, because we understand that there may be other sessions of this home fair that you want to jump out of this presentation to attend. There will be a copy of the presentation posted on SDCI's website, and I'm going to put that link in the chat. It will be available in the future. And one question I already have is this the same presentation as the one that's going to be done next Saturday for the home fair? So it's similar. Some of the same issues will be addressed in this presentation, as I'm sure will come up in the question and answer session in next week's home fair. But that session is really designed to be all question and answer. Okay, back to you, Dulcie.
Thanks, Maureen. And so without further ado, let's do this. So the overview. So trying to pick sort of the 10 most essential things that you need to know right now about renting in Seattle can be challenging because there's a lot to know. There are a lot of regulations. And those are in addition to state regulations or federal regulations. But we chose these topics because they tend to be the ones that people struggle with the most and or need help with understanding the most. So we're doing the top 10. We're going to talk about rental registration, fair housing, protected classes, who can rent, what can be charged, the rental agreement, repairs, notices, reasonable accommodation and modification, ending a rental agreement, and COVID-19. And the impacts of COVID-19. So since 2014, all rental units in the city of Seattle must be registered. There are some exceptions. So, for example, housing owned by Seattle Housing Authority are not subject to registration requirements because Seattle Housing Authority has their own inspection program. There are some other exemptions as well, but for the most part, almost all rental units must be registered. And there's a really good reason for that. I mean, until 2014, we did not know how many rental units we had in the city, which makes planning and creating policies and making sure that we're serving the people of Seattle very difficult if we aren't able to quantify. The other reason that registration is really important is that we want to make sure that any unit that goes out on the rental market is meeting the minimum standards and is safe for people to live in. And we have seen some hairy situations over the years on terrible living conditions. So it can happen. And this is one of the things that rental registration is designed to address. So registration is required to be renewed every 2 years, and then the property is going to be inspected every 5 to 10 years. There is a website that you can go to find out more about registration and check out the checklist that every rental unit must meet in order to be allowed to be a rental. And that's at www.seattle.gov/RRIO, which stands for Rental Regulation Inspection Ordinance. So minimum standards in housing, they basically cover all the sort of components of a housing unit that you could think of. So there are minimum floor area requirements for sleeping spaces and for living spaces. Obviously, there are light and ventilation requirements. There have to be windows, especially in sleeping rooms, for escape in the case of a fire or a flood. And ventilation. There has to be proper ventilation in bathrooms or areas where there's moisture. Sanitation, which would cover kitchens and bathrooms and plumbing fixtures. The structural components, which would be roofs, foundation, chimneys, any sort of masonry, any sort of structural support that would fall under that category. And then the mechanical systems would be electrical or heating. For example, a permanent heating source is required in a rental unit, and that means that it can't be a space heater. It has to be something that's permanently installed. Fire and safety. So lots of regulations around fire and safety. Stairs that have to be, a standard regular size. There have to be enough exits and egress, and there has to be smoke alarms and carbon monoxide alarms. And then security, there has to be secure entry locks, and every rental unit is required to have an observation port in the front door so that people can see who is at the door before they open it. So that's number 10, and I believe we're handing over to David for number 9.
Dulcie, before we move forward, there's a question in the chat asking, what are the legal requirements for a bedroom to be considered legal?
I will be happy to answer that, but I'll just have to go and check in my code book. So let me look that up, and I will answer that shortly.
All right. Well, I guess we'll move forward. As noted before, if you have any questions, feel free to ask them in the chat, and I'll be happy to answer them if they pertain to anything that I know about in terms of fair housing. So With fair housing, local, state, and federal law governs housing discrimination within agencies like my office, the Seattle Office for Civil Rights. And Seattle laws are actually often more protective than state and federal laws. Fair housing is the right of everyone to have equitable access to housing and housing services. And when looking at fair housing, it involves protected classes. An important thing to remember is that everyone is a member of a protected class, and people can be part of multiple protected classes. As you can see to the right of the PowerPoint, here are a list of protected classes within the city of Seattle. This includes race, color, national origin, religion, sex, disability, familial status, marital status, sexual orientation, gender identity, veteran/military status, age, ancestry, participation in a housing choice voucher program such as Section 8, political ideology, creed, alternative source of income, and other subsidies. Seattle does have a lot more protected classes than potentially other areas. The last time I checked, Seattle had more protected classes than anywhere that I could find, at least. So it is important to note that. And as I said, people can be part of multiple protected classes. For example, for race, my race would be Asian, but for sex, I would be male. So as in, I would be a member of protected classes in regard to two different categories of protected classes on this list. Next slide, Dulcie.
I think it's back to me. No, I'm sorry. It's you again, David. Sorry. Number 8, who can rent?
Number 8, who can rent? So the first thing I want to do is just walk through consider the list of protected classes we talked about and think about how those can translate to real life renting situations. For example, if someone were to come try to rent a property from you and they were a participant in Section 8, or they had an alternative source of income, as in maybe they receive income from some other source in an employer, you would not have the ability to turn them down because of those specific because of them being part of those specific protected classes. So the one tip I would give here is to get familiar with protected classes and fair housing if you are renting property out to make sure that you are able to be compliant with the laws that are enforced within the city. All right, now I want to move forward with Seattle First in Time Ordinance. Seattle's First in Time Ordinance requires landlords to offer rental units to the first person who submits a completed and qualified application. So what this means is that the first applicant who submits a completed application that meets all the requirements you listed, you would be required to rent to them. So the thing with this is that in your application, in advertisement for the property, you want to clearly list what your requirements are you're looking for, the process to submit an application, what is required in the application, things of that nature, because once an applicant submits a complete application that meet all those requirements, you would be required to rent to that very first person. And the important thing to also note here is to mark the dates when you do receive a completed application and make sure to screen applicants in the order that you do receive them. Now I want to move forward to Seattle's Fair Chance Housing Ordinance. What that is, it means that it's illegal to ban applicants with criminal histories and or screen applicants for criminal history. With that being said, this applies to advertising. For example, you cannot put on your advertising, do you prohibit people from renting who have arrest records, conviction records, or criminal history. A big important thing here is that you would not be able to screen applicants for criminal history. There is an exception to this. There are exceptions to screening here, but you would not be able to screen for criminal history, excluding a person being part of the state or national sex offender registry. So you would be able to look at those databases, but you would not be able to screen for things such as other criminal convictions or things of that nature. And it's important to, yeah.
Excuse me. We have a question about the first in time regulations in the chat box, and I thought I would put it out there to you while you're on this slide. And that is there a minimum number of units per property? Is there some kind of exception if it's a smaller building?
To the best of my knowledge, I do not think there is an exception for it being a smaller building. There are certain exceptions that you'll want to look into specifically, but being a 4 units in the building, I don't think there would be an exception to that. But again, you'll want to look into you can go to our website for more information. As Dulcie said, the Renting in Seattle website will have a lot more information on that. But to my knowledge, if the building has 4 units, it would still apply. In terms of I do want to talk about actually exclusions for the Fair Chance Housing Ordinance. So federally assisted housing subject to federal regulations that require denial of tenancy for lifetime sex offender registration or convictions of methamphetamine production in housing, you would be potentially excluded from the Fair Chance Housing Ordinance. Or if it's renting a housing where the owner occupies part of the unit. So let's say you're renting a room out and you do live in that property there. You would be excluded from the Fair Chance Housing Ordinance. Or accessory dwelling units or detached accessory units where the owner maintains permanent residence on the same lot. So let's say you own a property, and on that property you have an ADU, and you're renting out the ADU. If you're actually living on that property, it would also be an exclusion from the Fair Chance Housing Ordinance. And as stated here, applicants may not be screened against sexual offender, may be screened for a sexual offender registry, but cannot be refused housing for that reason alone. So if you do find out that someone is on one of these registries, a landlord still must provide a legitimate business reason. So the big thing there is to, if that does occur, you'll want to research more what your requirements would be for that. But you would not be able to decline someone on that alone. You would need a legitimate business reason, which goes a little deeper than we're talking about here today. So again, feel free to go to the website to learn more about that. I believe we have a question. Let's see. Owner-occupied units are exempt, but the size of the units has no bearing. Okay, Dulcie. All right, I believe we're on to the next slide.
Thanks, David. That's a lot of information for us to go through. I appreciate that you were able to
I do actually want to say one last thing on that. Again, as I was highlighting before, these are very specific laws and covers a lot of information. That's why I keep highlighting that I really think it is beneficial to go to the website, learn more about these laws that are enforced within Seattle, because they will apply to you potentially if you are renting units in Seattle. It's very important to be up to date with the specifics that will apply to your potential unit.
Thanks, David. Somebody just asked if we could post the address of the website that David is sending us to, and it's going to be on the end of this, but it's very easy. It's www.seattle.gov/renting in Seattle. And again, that's going to be on this PowerPoint later on in some of the slides, if you didn't catch that. So now we're on to number 7, which deals with sort of the monetary things that you should know. So in Seattle, there are strict limits on charges that can be made. And most of this applies to people when they're moving in, which is when, you know, the monies are paid. So application fee, you can only charge strictly the cost of what the application fee is. Typically in Seattle, it's about $45 per adult. You can charge a holding deposit. It is regulated by the State Landlord Tenant Act, and it is limited to 1 month's rent. If you do charge a holding deposit and the renter is successful, their application is successful, then you would need to apply that holding deposit to the first month's rent or the security deposit. You can charge a security deposit and you can charge a cleaning fee, but know that application fee plus cleaning fee equals a maximum of 10% of 1 month's rent. So if you are going to be charging a cleaning fee in addition to an application fee, those combined, the cost combined, cannot exceed, 10% of 1 month's rent. And then the security deposit plus the application fee plus cleaning fee can only must not exceed a maximum of 1 month's rent. So really, unless you're renting a very expensive, high-end unit that costs a lot of money, there generally wouldn't be enough in that 10% to cover cleaning as well. Pet deposit is a maximum of 25% of 1 month's rent. And that's regardless of if you have one pet or two pets, it's 25% of 1 month's rent. Pet fee, there's no such thing as a pet fee. That fees for pets are not allowed. Pet rent is not unlawful, and people do charge pet rent in some units. But pet fees are not allowed. So if you take a pet deposit, that must be 100% refundable. That's the definition of deposit. So no other fees are allowed. And in fact, a lot of this legislation came into being because there were so many fees associated with applying or moving into a property, these sort of vague administration fees or paper pushing fees. So they are not allowed now. Only what's stated here can be charged. And I should mention also that pet deposits are not allowed to be charged for service animals. Service animals are not considered pets under the law. And so it's a different consideration when it comes to service animals. David will be talking about service animals a little bit on one of his slides later on. So no other fees are allowed to be charged, and installments are required if the renter chooses to pay over a schedule. So generally speaking, for installment payments, it depends on the length of the rental agreement. Also, a landlord and a tenant can agree to their own payment schedule. It is a lot for a lot of people to come up with to move into a place. It's usually 3 months rent, if not more. And plus the costs of actually physically moving. So Seattle wants it to be more affordable for folks. And that's why if a renter elects to pay in installments for their move-in charges, they can. And they can do that with their last month's rent. They can do it with their pet deposit, security deposit. And a landlord cannot refuse to accept installment payments, nor charge extra for installment payments. I think I saw a hand raised, although we were saying that we would take questions in the chat room. Is there a question in the chat room? I did see a hand raised. In situations where landlords pay water, sewer, and garbage, are landlords allowed to reduce rent and have tenants pay water, sewer, and garbage? So what I would say to that question is, the who pays for the water, sewer, and garbage is decided at the beginning of a rental agreement generally. So if you're in a lease where if you're in a lease agreement where the term is for 1 year, you can't change the terms of the agreement unless it's mutually agreed upon by the tenant. And then if you do want to change the terms of a rental agreement so that the tenant now pays water, sewer, and garbage, you would have to make sure that you gave adequate notice. Generally speaking, 30 days advance notice for a change in terms to an agreement. But in the case where it could result or will result in an increase in housing costs for the renter, you would have to follow the notice requirements for increases to housing costs. So that would be a 60-day notice. So I'm going to keep going. I see that there are other questions, but I am going to just keep going, and my colleagues can let me know if there's something I should answer. So We're talking about the rental agreement. The rental agreement is a really important center stone of any tenancy, and it's designed to give protections to both the landlord and the tenant. A rental agreement clarifies basically what you are legally bound to do contractually pursuant to that rental agreement. And so it's really important that whether you're the landlord or the tenant, you understand what's in that agreement. And they can be complicated because they have legal language and so on and so forth. But it is really important to understand what you're signing up for and what it will mean in real terms. Seattle has many regulations specific to the city that do not apply outside of Seattle. And so we really discourage people from trying to use rental agreements, generic rental agreements from websites and so on. It's really important that you use a comprehensive rental agreement that's specific to the city. We know that Rental Housing Association, they would be one of the largest landlord advocacy groups in the area, and they provide rental agreements to many housing providers. And their rental agreements are tailored, for example, to the city for their clients that live within the city limits. Also be aware that there are state landlord requirements, Landlord Tenant Act requirements for the rental agreement. So for multifamily buildings, there has to be information about fire safety. There has to be a lead paint disclosure if the building is older than a certain age. There has to be a move-in checklist if you take a deposit. If a landlord takes a deposit, or as a tenant, if you charged a deposit, there has to be a move-in checklist. And the move-in checklist is basically describing the condition of the property in reasonable detail so that at the end of the rental agreement, both parties, both landlord and tenant, can look at that checklist and compare the checklist to the condition of the property at move out. And that is what the landlord has to consider when they're calculating what they're going to return in the security deposit. If a security deposit is taken without a move-in checklist, it would be taken unlawfully and would need to be refunded. There are three types, main types of rental agreements. There's a rental agreement that's for a specific period of time, and it may or may not end at the end, or it may be renewed. There is a terminating type of lease agreement, and that basically says in it that at the end of this agreement, at the end of this term, the tenant has to move out and there's no staying on. Now, often with these terminating leases, the tenant does stay on, but it is a negotiation with the landlord at that point. The important thing to know is that if a tenant signs a terminating lease, they are giving control about what happens at the end to the landlord. And so if the landlord decides not to continue renting, and this is the first lease that they've had and it's a terminating lease, then they can require the tenants to leave at the end. So that's very important if you're signing a rental agreement on a unit for the first time and you're not looking to move and you're looking for long-term security. And then the third type is the month-to-month rental agreement. Sometimes rental agreements begin as month-to-month rental agreements, but I would say in my experience, the majority of month-to-month rental agreements occur after there's been an initial lease term, and then it lapses and reverts to a month-to-month agreement. And basically a month-to-month agreement is just as it sounds, it renews monthly, usually on the first of every month when the rent is due.
Dulcie, quick question there.
Yeah.
It's from the chat, it's related to this. Are landlords allowed to convert a month-to-month agreement to a fixed-term lease agreement?
So if a tenant has been month by month at any point in their tenancy, they will always have what's called just cause rights, which means that if a landlord wants to have them move out, they'll have to have a just cause. So if a landlord wanted to fix the term for a certain period of time, it's a negotiation with the tenant, because the advantage for the tenant is that it fixes the rent amount, secures the rent amount for a certain period of time. If a renter has a month-to-month agreement, the landlord can change the rent and also the rules or the terms of the agreement with proper notice. So if the landlord wanted to put a month-to-month tenant on a fixed term, there's nothing unlawful about that. It would need to be discussed with the tenant. But if that new lease looked to try and displace the tenant at the end, that would be unenforceable. So you couldn't convert a month-to-month tenancy into a lease term that would then result in the tenant having to move out at the end of it. I hope that answers the question. If not, we can talk about that more, or if Maureen has anything to add, I would welcome her input. No. Okay. So some of the most important provisions that are in lease agreements are, one, how long is the term for and what happens at the end? So that's the first thing you really need to be clear on. Both parties need to be very clear on. Things like policies on late fees, or policies on guests staying, policies on pets, policies, or what are the provisions on who's paying for the utilities, who's responsible for maintenance of the yard, if there's a yard space that comes. So all of those things are really important to understand, because some of those things are going to be obligations that you're agreeing to, and you should be aware of those before you sign any agreement, and it should be clear. And it's a good point to make here that the burden for any land, the burden is always going to be on the party that provides the legal contract. So it's necessary for the contract provider to make the agreement clear. That is their responsibility as the person providing the contract, which is why it's really important to use a properly prepared rental agreement by a qualified legal professional that is specific to the area in which you live. I see here, if you move a tenant from month to month and go into a term lease, at the end of the term lease, you are saying that they do not have to vacate. What is the point of a term lease then? So the point of a lease for a term is just to fix fix for a certain period of time how much rent and all the other terms of the agreement. That's all that the point of a term lease is. A terminating lease is the one that has that language in it that says you have to leave. So the question is asking, why can't you use a lease agreement to displace the tenant who has been month to month? And the reason you can't do that is because tenants who have been month to month during their tenancy have protections under the just cause eviction law, which means you have to have a just cause to displace a tenant. I'm going to talk a little bit more about that when we talk about what happens at the end of a rental agreement. So number 5, repairs. So repairs are often the reason why tenants call the city, why they call the Department of Construction and Inspections. And I always tell landlords, it's really important that you respond promptly and comprehensively to repair requests, because when a tenant calls us because a landlord is not making necessary or required repairs, that then basically turns into a potential inspection. And if an inspector goes out to your property they may see things in addition to the repairs that the tenant is requesting that might be code violations. So it's always worth it to take care of the repair request promptly to avoid having an inspector coming out to your property and seeing things that maybe they don't necessarily need to see. And I'm not talking about things that would be unsafe. I'm talking about just things that are in the code for good reason. But at the end of the day, if you take care of your tenants and when they request repairs, it's a way to avoid having the city come out to your property. So repair requests are required to be in writing according to the State Landlord-Tenant Act. As I've already said, landlords should respond to issues promptly. Some issues are more urgent than others. Efforts should be documented. So if a landlord is taking steps to get a contractor out or get a repair person out, just make note of that. Document your efforts so that if it ever comes into question, you can show that you took the appropriate steps and you fulfilled your obligations. Either way, the tenant requesting the repair or the landlord trying to make the repair. So like I said, the process for the city is that if a tenant calls to complain, we'll basically schedule a day and time to inspect the unit, and an inspector will go out and write up a notice of violation listing anything that the landlord is being required to correct. For non-urgent things, there's usually a 30-day period to comply, but for things that are more urgent, like appliances or water fixtures, things like that, there would be a much smaller turnaround time. And if there was a lack of water or power or heat to any rental unit, we would consider those emergency conditions and we would come out and inspect on the same day. And we usually require turnaround within 24 to 48 hours from a landlord. And if a landlord refuses or for some reason cannot meet that compliance timeline, there is a chance that the tenants would have to move out and relocate, and the landlord would have to pay relocation financial assistance. I see a question. Do owners get a reminder when the RIO needs renewal? Yes, you do. You get a reminder. That was just a quick question I was able to see in the chat. So number 4, notices. So notices really are the formal way to communicate with a tenant or a landlord, if you're the tenant writing a notice to your landlord, that has some kind of material impact on the rental agreement. So it's really important that notices are technically correct because there are technical requirements for notices. Specifically in Seattle, we have a few different requirements. And without those technical correctness on the notice, it could be rendered deficient. It could be required to be rescinded by the city if the tenant contacts the city and complains about a notice that they've received and it's not valid or it does not have the necessary language on it. So it's really important that you, again, use either a source that provides proper, technically correct notices, or you consult with an attorney if you're going to be issuing formal notices to a tenant, because it can really delay a process or mess up a process if it's not correct. So for housing cost increases, 60 days advance written notice is required. I see a question. Is the cost increase requirement 60 days when the increase is 10% more? So Eleni, it used to be that Seattle had 30-day requirement for increases under 10% and a 60-day requirement for increases of 10% or more. But the state actually changed the law to require 60 days for any housing cost increase across the state. So now it's 60 days regardless of what the percentage of increase is. Thanks for your question. So the 14-day pay or vacate, so it used to be for many, many years, it was a 3-day pay or vacate notice is what a landlord would issue when a tenant didn't pay their rent on time. And that was really a very arduous standard to have to meet to be able to try and find funds to pay your rent within that 3-day period. So for good reason, the state law was changed in 2019 to facilitate a new 14-day pay or vacate notice. And so that's now what needs to be issued to a tenant if they do not pay their rent by the due date. Other changes around that 14-day pay or vacate notice that happened at the same time is that now utilities can be considered rent. So if the tenant owes utilities on the property and they're responsible for utilities, those can be included in the 14-day pay or vacate. And the only other thing that you can include on a 14-day pay or vacate notice is missed installment payments. So if installment payments were missed for the move-in costs, then you could also include those on a 14-day pay or vacate notice. On the 10-day comply or vacate notice, this is a notice that is used when a tenant is violating the rules of the rental agreement. So typical violations would be noise. There's a lot of noise violations, or keeping a pet where there are no pets allowed, or smoking. That's often an issue in units that are non-smoking. Those would be typical 10-day comply or vacate notices. As I mentioned earlier, when a landlord wants to change the terms of a month-to-month rental agreement, the notice requirement is 30 days, unless, of course, it involves an increase to their housing costs. And that all of these notices, all of the time periods, those are minimum notice requirements. So if you want to give more notice, that's fine, but you can't give less than these notice requirements. And you cannot include the day of service in these notice requirements. So you have to serve the notice, and then there has to be that full 14 days or 10 days or 30 days. And it has to coincide when it's a 30-day change to terms or a housing cost increase. Those have to coincide with a rental period, so they only go into effect on the first day of the rental period, which is usually the first day of the month. Notices in Seattle must include information about where a renter can find information on their rights. And the required language, or the language that will meet the standard required, is highlighted here. And that should be on all notices that you send to a tenant or that a tenant receives. So David is going to pop in here and talk about the very controversial subject. That's usually how it is when we're out in the community talking to landlords and tenants about service animals.
All right, thank you, Dulcie. Before I get into service, there we go. There, now I can hear myself. All right, now we're gonna go into service animals. But before we get into that, I want to cover a little bit about reasonable accommodations, give a broad overview of that, because service animals would be a form of a reasonable accommodation. Federal, state, and local fair housing laws require that housing owners and managers provide reasonable accommodations for applicants and residents who have disabilities. A reasonable accommodation is a change to policy, procedure, rules, or practices that may be necessary in order for a person with a disability to use and enjoy the dwelling. And again, as noted before, that does include service animals, as all assistance animals, including service animals, companion animals, and emotional support animals. Important thing to note is that a landlord cannot have a requirement that the animal was trained by a service animal school. And there is no such thing as a certification of service animals, as there is no state or national standard for what constitutes a certification. But a landlord could request a verification letter from a qualified third party if necessary, which I'll cover a little bit next. As Dulcie noted before, you must waive pet policies. They would not apply to a service animal, so you can't have a no pet policy apply to a service animal. You can't have a pet fee apply to a service animal, pet deposit, pet rent, no dog, breed restrictions, things of those nature. You would not be able to apply to a service animal as they're not considered a pet under the law. Next, I want to talk about the verification process. I know there was a question about that earlier. So in situations when a disability is not known or obvious, and or when the need for accommodation is not known or obvious, you can request certification from a qualified third-party source. So what verification can be requested? You can ask for verification for the need of the service animal and the disability. What you can't ask for is specific information about the disability, like you cannot request records or things of that nature. All you can request is verification that the disability is needed, and who can provide it? Qualified third party with knowledge of the person's disability. So what makes this different than some other things, as in qualified third party with knowledge of the person, doesn't mean it has to be a medical doctor. This example could be maybe a mental health therapist, a counselor, things of those nature. Anyone who's qualified with knowledge of the person's disability and the need for the service animal. And as noted before, again, no pet policies can apply here. And service animals can include more things than just dogs. Basically, any animal that's legal to own in Seattle could potentially be included as a service animal. Dogs, cats, fish. There are animals that are not legal in Seattle would not qualify, though, potentially. Are there any questions before I move on here? Because I know there is always questions typically about service animals. What about people that apply to online service for verification? That's actually a good question. So I know there are a lot of online service verifications. In terms of verification, the big thing that I say here is to interact with the person. When they provide, it's the interactive process that's really huge here, by talking to them, asking questions to them, and asking for verification. In terms of the online services, if the person is qualified to discuss and their need for the accommodation, it could be valid. But that would be on a case-to-case basis, which you'd probably want to do a little more research into at that point, because they could be qualified, but it's also possible maybe the person actually never met with the person, or they didn't provide any information. It was just given to them from some online website, which may not be verified. It all depends on the person's knowledge and if they're qualified to discuss about the need for the accommodation. How is a fish a service animal? If, for example, let's say it's been identified that the fish allows them to live in the housing with their disability, let's say the fish is a way that helps them enjoy the property based on their disability. Again, that's a hard question to answer because it really depends on the disability. There are situations where a fish may help with a person with a disability fully enjoy the property. Again, it would be very case-by-case basis. So that's all I can say about that specifically. I believe that's all the questions. And a fish I also want to note, a fish is one animal I listed because it's a general animal that you could have living there. I haven't seen many cases where the fish is a emotional support animal or service animal, but that can come up. That's why I just noted that. There's anything that would be legal to own in Seattle potentially.
I would just add that disabilities are there's a lot of different kinds of disabilities, and we don't necessarily have to understand them or know about them to be respectful that they exist. And Seattle's service animal protections or policies are definitely designed to be liberal. And that's why they cover emotional support animals. So a fish could be an emotional support animal for somebody. That is not outside the realm of possibility. So it just really depends on the individual situation and an individual person's disability, like David said.
And David, there were 2 additional questions that came in.
Let's see. Could a rabbit be considered a service animal? Yes, potentially. As we discussed before, if it's identified that the rabbit, based on the person's specific disability, the rabbit would be potentially something that could be considered a service animal based on, if you do request verification of that, based on the verification from the third party provider. But yes, it could potentially be a service animal. Maureen, can you help me with the other question you said?
Yes, the other question was, is there a list of animals that aren't permitted in Seattle? I'm assuming in the context of service and emotional support animals.
That's possible. I would not know where that is right now. It would basically be animals that aren't allowed in Seattle to own in general. So, such as, I believe there may be laws against certain wild animals that they consider that would potentially fall under that, but I do not have that list available, or I do not know where that would specifically be at this time.
Okay, and as you predicted, the questions are starting to come in on service and emotional support animals. The question is, effectively all animals are allowed because anybody can register a pet as emotional support animal. Is that correct?
Not necessarily. So, as I stated before, animals can be service animals, but a person would need to. It needs to be disability related. So there has to actually be a disability related need for the animal. So that's the big thing there. That, as Dulcie said before, there are a number of disabilities out there that a lot of we may not understand or we may not know about. But if the qualified third party professional is able to verify that this service animal assists with their disability, it could be something that could be considered a service animal. But the big thing is it has to be disability related. That's the big thing there. So not all animals could be, I guess, considered service animals unless it actually is related to the disability.
And then I think this goes to something you've already talked about, but asking about different kinds of animals, and that it's a very broad list of animals that could be included, particularly with an emotional support animal. The question is, can a chicken living in a coop be considered a service animal?
I do not know the answer to this because I think that would also go to rules and policies about chickens living in coops in general. Is that I don't know specifics about that in Seattle, how that would apply, or that's a very specific reasonable accommodation request that I don't think I can answer 100% right now, and I only want to provide information today that I can answer with confidence. So that one is something that you may need to look more into specifically if that were to ever come up.
I just want to weigh in here and say that there are some rules around what kind of animals you can keep in the city. That is not something that is, I believe, regulated, but it's definitely not regulated by the Seattle Office for Civil Rights. The Department of Construction and Inspections, I think, has some sort of some type of relationship to that. I know that, for example, roosters aren't allowed in the city of Seattle. So roosters are not allowed in the city of Seattle. Now, I think David has answered as best as he can that really any animal has the potential to be a service animal. We just don't know what, with regards to people's specific disabilities and their specific disability related needs. But if there can be a connection made, if there is a connection between the person's disability and their disability related need for this service animal, then I think it meets the standard. But again, it's in the more complicated sort of situations. I mean, we've had this come up before, tarantulas, service animal tarantulas, service animal snakes. You can think about these exotic animals or unusual animals, and they don't resonate with us the way maybe a guide dog would. It's not as obvious to us, but that doesn't mean to say that it is not actually a service animal in the eyes of the law, and that it can't meet that relationship between the disability and the disability-related need. So I hope that's as thorough as we can get on that, because again, it can be specific to each person.
Yeah, and just one last thing I want to say, as Dulcie said, it's really that nexus there between the disability and the medically necessary need for the service animal. And that nexus that bridges those things together, that's the thing that would need to be looked at on a case-by-case basis, potentially. But that's what's required for a service animal.
I think there's one more question about owner allergies. David, if you want to take that before I go to the next slide.
All right, I would answer that. What if an owner is allergic to dogs? For example, can the tenant be denied for owner's health reasons? So one reason that a service animal could be denied is called a direct threat, where there's actually evidence to show that the service animal is a direct threat to potentially other tenants and things of that nature. If this situation you listed here, it may not. It would be very fact specific, because generally, is there a way to make this accommodation work without, even though the owner is allergic? For example, is there you would really want to engage with the tenant here about their specific situation, and maybe there's a way that this animal could still be allowed to live there without it impacting the owner. Maybe the owner isn't there at a specific time. The owner isn't there all the time. Maybe it doesn't impact the owner that way, but it would have to be evidence to show there's a direct threat. And from what I understand in general, allergies typically are not a reason that is typically upheld to deny a person allow them to have a service animal, but you would want to view these on case-to-case basis and interact with the tenant to see what accommodation could be provided.
As usual, our service animal segment is one of the liveliest segments we always have. We understand the feelings around service animals and how complicated it can be. And so moving on to number 2, which is ending a rental agreement. So we all hope that rental agreements end by mutual decision, and that can go a number of ways. It could be just that the lease term expires and the tenant wants to move on, or the landlord wants the tenant to move on. So first thing is, what does the rental agreement provide for the end of the agreement? And there is a difference between terminating a tenancy and the formal act of evicting somebody. Even though the words can be sometimes used interchangeably, eviction is an actual lawsuit process that has to go through superior court. And termination can just be a landlord giving a proper notice to terminate a tenancy to a tenant with no need for any court action. So if a tenant is month by month in the city of Seattle, you have to have a just cause reason to terminate that tenancy. And in fact, every landlord has to have a just cause to terminate a tenancy, but the just cause eviction protections that Seattle has an ordinance for are enforced on behalf of month-to-month tenants, because under a lease agreement, the lease agreement is what's governing how the agreement ends. So there are about 16 just cause reasons to terminate a tenancy in Seattle. The most common ones would be failure to pay rent, or habitual failure to pay rent. If you have to give 4 or more 14-day notices in a 12-month period, that would be just cause to terminate a tenancy. If you gave a 10-day notice for violating the rental agreement and the tenant didn't comply, that would be a reason. Or if you had to give 3 or more 10-day notices within a 12-month period, that would be a just cause. Some other just causes require payment of relocation assistance to tenants. So for example, if somebody is developing a property or changing the use of a property or demolishing it, then they would need to go through a relocation licensing process through our office. And if the tenants were income eligible, they would receive relocation assistance. If a tenant had to move out because of no power or no heat or no water, as I said earlier, that would require, if the condition was under the responsibility of the landlord, if the condition that caused the emergency was under the responsibility of the landlord would need to pay relocation assistance in that situation. So in order to terminate a tenancy, a month-by-month tenancy, you must provide proper notice and you must serve the notice properly. So the notice has to say, what is the just cause? It has to give the correct amount of notice. For example, if you want to sell your house and you want the tenant to move out to facilitate the sale of the house, that is a 90-day advance written notice, for example. So that's terminating a tenancy. If a tenant doesn't move out pursuant to a lawful termination notice, then they would need to go to court to have the judge restore their right to possess the property again. Or if a tenant doesn't move out pursuant to a notice and there is a dispute about the facts around what's on the notice, and the tenant refuses to move out, then the landlord has to file an eviction lawsuit in Superior Court if it cannot be worked out with the tenant. That is the only way to legally remove somebody from your property when you want to take your property back. And the eviction process and the regulations around it were revitalized, I guess, in 2019, along with that 14-day notice. And so there are lots of requirements now. If you are going to evict a tenant, there's standard language in the summons and complaint that you have to serve to a tenant. Really, anyone who's going into an eviction lawsuit, whether you're the landlord or the tenant, you have to have legal representation. It is not something that you would represent yourself doing. So that's the process. Basically, those are the things that happen at the end of a rental agreement. The other thing to remember is that there is a security deposit obligation. The landlord has to return the security deposit within 21 days. And as we talked about earlier, that checklist is the important document that you consult when you're looking to calculate if damages were done and whether you have a right to any of the deposit. And there is a difference between reasonable wear and tear and damage. And generally speaking, reasonable wear and tear is something that happens gradually over time from the normal use of something. So, tread marks in a carpet from where people walk, or smudges on walls, on paint over time, or the wearing down of something, of surfaces. That's all just from normal use. Damage usually happens suddenly and is either accidental or through some type of negligence. But you have to return the deposit within 21 days and a statement supporting the basis upon which you're keeping any of the deposit, and it should be reasonably outlined in detail. The city tries to stay out of disputes about security deposits. We're not really wanting to be involved in any disagreements about what constitutes damage versus wear and tear. That's more of a small claims court type facilitation. But we are looking to see that the 21-day rule is being followed. We are looking to see that there is a move-in checklist to support the taking of a deposit in the first place. And we are looking to see that the deposit return statement is reasonably itemized and not just, as we've seen, believe it or not, a figure like $300 for sweeping or $300 for paint touch-up. It needs to be a bit more specific than that so that the tenant can see what the damage is and how much of the deposit was taken to cover that damage. So now we get to, I'm sorry, I'm going to look and see if I've got some questions
We
here.
do have some questions.
All right.
Yeah, we got a number of questions for this one.
Okay, so let's have a look. Sorry, I don't know why I don't know how I muted myself there. That was accidental. So regarding the deposit return in Seattle, Seattle Public Utilities is billed to landlord. The bill comes out every 2 months. If a tenant moves out end of May and SPU doesn't come out until second week of July, can landlord hold on to a portion of deposit beyond 21 days to cover the SPU bill? So basically, if there is some kind of condition or circumstance that's preventing you from being able to decisively calculate what's owed back within that 21-day period, you would need to let the tenant know in writing and make sure that you support what you're saying with some documentation. So if there's an outstanding utility portion of the bill, you can't fully calculate what is owed until you know what is owed. Although I don't know if there would be a way to get a meter read or something like that, but yes, I mean, if there are circumstances that prevent you from meeting that 21 days and they are reasonable and legitimate, so long as you communicate in writing to the tenant, I think that that would be okay. I see a question from Sue. 90-day notice during COVID, the only permissible if there is an imminent threat. Yeah, so Sue, our number one thing to know about renting in Seattle right now is that sort of everything is different under the current COVID-19 emergency order and moratoriums, and we'll talk about that on the next slide. Yeah.
There was one other question related to this slide ending a rental agreement.
Yeah.
And it was when the lease expires and reverts to month, if the owner chooses to sell the house, does it still require 90-day notice, consequently making it a 3-month, month-to-month tenancy?
Yes.
So I think basically, do you still need to give those 90 days notice if you're going to sell once it reverts month to month?
Yes, is the answer. You always need to, so when a lease agreement automatically reverts month to month, it means that the tenant has a right to stay on after the initial period. So you would have to have a just cause. Therefore, if you wanted to sell, you would need to meet that 90-day requirement. I see, what about large nail holes for mounting TV on the wall? Would that be considered normal wear and tear? This is sort of getting into the weeds, but I would say that you should be addressing nail holes or what's permissible in terms of what can be attached to the walls, etc., in the lease agreement. And then you can decide based on what the lease agreement says in terms of whether it's damaged or not. So I would say, some of these TV mounts can do damage to the wall, and there would need to be some repair to drywall, etc. I would say that would probably meet damage, but it really is hard to say. And ultimately, I don't make that decision. That would be up to the tenant and the landlord to reasonably decide between themselves. And if they could not agree, then it would be for a judge in small claims court to decide. Sometimes there are gray areas when it comes to damage versus wear and tear. Do you have to get the repair done in order to keep some deposit? You would need to either do the repair or have a bid to show how much the repair is going to cost, because it's not always possible to get a repair done within that time, but you would need evidence to show that this is what the damage is going to cost to repair. do you have to get an estimate from contractor to keep some deposit? If you're keeping the deposit because you need the help of a contractor to fix the damage, then yes, I would say yes. There seems to be disagreement about cleaning responsibilities, professional cleaning and professional carpet. If this was done prior to move-in, is it allowed to be charged at time of vacating? I am aware of the Seattle court considering it normal wear and tear. Please explain. We talked about, that the only fees that can be charged at the time of move-in are for cleaning and screening. But because those fees are limited to 10% of 1 month's rent, that would generally not be able to cover the cost of a basic cleaning or cleaning an apartment or a property. It just wouldn't in most cases, unless it's a very large rental amount you're paying every month. So if you do though decide to charge for cleaning and under that 10% total along with the application fees, you cannot charge for cleaning anywhere else. You can't charge for cleaning at the end. I don't think that there's anything preventing somebody from having in their rental agreement, and Maureen, correct me if you disagree with this, but I don't think there's anything unlawful about saying in the rental agreement that the carpets have been professionally shampooed and they need to be professionally shampooed at move out. I don't think there's anything unlawful about putting that into a rental agreement, but I don't think that you could take the cost of it out of a deposit, for example. Maureen, do you have any comments?
Yeah, so they're actually, Dulcie, I'm going to mute you because I get a lot of feedback when we're both unmuted. There are a lot of questions that come through SDCI about security deposits and what can be deducted. I would say with, the requiring your tenant to have a professional cleaning is something you could require in the lease agreement. I would be careful if you're trying to charge for carpet cleaning and things of that nature, particularly if the carpet was not new when the tenant moved in, for damage to the carpet that would be considered normal wear and tear. It's a really subjective thing. And it's one of the reasons SDCI does not get into the middle of disputes between owners and tenants about, was the damage significant enough to warrant the deduction from the security deposit? What SDCI looks at when we get a complaint for a security deposit return is, did you do the process right? Did you notify the tenant within 21 days? Did you take that move-in checklist at the beginning of the tenancy? Did you give the tenant an itemized list of why you were withholding any part of the deposit? And did you return the balance if there was any money left over? So it can be really challenging. I think the clearer you can be in your lease agreement as to what the tenant will be responsible for upon move out. And I would strongly recommend doing a exit walkthrough with your tenant so that everyone's on the same page as they're leaving their rental agreement.
Thanks, Maureen. Thanks for those words of wisdom. The State Landlord Tenant Act basically provides that a renter is required to return the unit in the condition they received it, minus reasonable wear and tear. So that's the standard. And like Maureen said, views on cleanliness and standards of cleanliness, professional, amateur, or otherwise, are very subjective. So it's always going to be one of those gray areas. But rule of thumb is that the unit should look pretty much like it did at the time that it was originally rented, minus those wear and tear things that we mentioned. I know I often hear from tenants that they leave units cleaner than they rented them. So, it can go all kinds of ways. But those are some of the gray areas for sure. So now we're down to number 1, which brings us to our current situation, COVID-19. So, as we all know, as we've all been living in the world with this global pandemic, a state of emergency was declared in March of 2020. And under that state of emergency, both the state, both the governor and our city mayor, put in force eviction moratoriums that have been continued. I think it's maybe the fourth continuance now we're on. And currently those moratoriums are due to expire on March 31st. We don't know currently if they're going to be renewed again. We generally don't get a heads up until very shortly before they expire. So that's what I can tell you about the current moratoriums. There's been a lot of confusion for landlords around the differences between the state moratorium and the City of Seattle moratorium. And we understand the confusion because we found it confusing too in the beginning. But we know that in Seattle, the only reason that a tenant can be evicted currently is if they present a hazard to health and safety. There are additional exemptions under the state law, but those do not apply to Seattle. And we are hearing reports and seeing that when it comes to landlords attempting to evict tenants for anything other than they present as a hazard to health and safety, that the judge is ruling in favor of the protections offered by the Seattle moratorium. So in the rest of the state, a landlord can evict a tenant if they want to sell their property or if they want to occupy their property, or if there is severe damage to the property that they weren't aware of prior to COVID. But in Seattle, the only reason, again, I will say it, is if a tenant is preventing a hazard to health and safety. There are no exceptions. And there are those in the development community that we work with in our relocation licensing process in our office that that can get a good reminder now that even if you have a license through that process, you cannot activate that right now. You cannot remove a tenant until this moratorium is changed or it is over. This is the only reason to evict a tenant in Seattle right now. Some of the additional protections that are included are you can't increase housing costs while the moratorium is in effect. Tenants can't be charged interest or penalized for unpaid rent. Tenants can't be harassed or threatened because they haven't paid their rent. Payment plans are required based on the tenant's ability to pay, but there is a requirement that both parties engage in good faith to try and come up with a reasonable payment plan that is sustainable. Tenants are definitely being reminded by our staff and by even the moratorium that they still have to pay rent. This isn't a forgiveness of rent or rent-free. This is not about not having to pay your rent. It's that you just can't be evicted for that reason for now under the moratorium. And then the definition of tenant has also been expanded under the COVID-19 moratorium to include people who would not ordinarily be considered tenants, people who are staying in hotels for longer than 14 days, things like that, people in mobile home parks and other folks are being offered these protections temporarily under COVID-19. And so once the moratorium is over, the City of Seattle has put in place a recovery period of approximately 6 months. Some of the provisions will have longer span of protections, but for a period of approximately 6 months after the end of the emergency order and after the moratoriums are declared over, there will be a period of time where there will be additional protections to try and help with the transitioning into a recovery period. One of those, and probably the main protection, would be that inability to pay the rent is now considered a legal defense to eviction if the tenant can provide evidence that the inability to pay the rent is due to the impacts of COVID. So it's not a moratorium, but it is a recognition that this is a defense to eviction for this period of time if the inability to pay the rent is due to the impacts of COVID-19. Some other protections are, again, no late fees can be charged. Maureen, do you want to weigh in here with some of the other recovery protections?
Yeah, so sorry, Dulcie. I'm going to have to mute you again. All right, I don't know why we're getting so much feedback when Dulcie and I are both unmuted at the same time. I promise you we are not in the same space. So yeah, after the moratoriums expire, the city has put COVID recovery protections into place in two forms. One is, as Dulcie talked about, a defense to an eviction for non-payment cases for a 6-month period after the moratorium expires, and that is really to help people get restabilized. But it's not a ban, it's not a prohibition on evictions. There's an accompanying law that requires a payment plan. So the payment plan that the city passed in May of 2020, that requirement is for individuals who are fallen into non-payment, and it talks about, very similar to move-in costs, establishing an installment-based payment plan with tenants. It doesn't mean you can't move forward if the tenant refuses to engage you in those discussions, or if the tenant defaults on a payment plan that they've entered. In addition to those protections, we talked earlier about requirements of language that need to be on notices. So with the extended COVID relief recovery protections, there is additional information that needs to be provided to tenants on a 14-day notice to pay or vacate once it is permissible to issue those again. So first you would have to include language, and the specific language is directly in the code. I can put a link to that in the chat box when we're done here. But essentially you have to notify tenants that COVID-related non-payment can be a defense to an eviction in the notice, and you also have to let them know that they have the right to a payment plan in the notice. So similar to looking for the renting in Seattle language that's required in those termination notices on the 14-day notices, our department would also be looking for that additional language. So there really is a lot of meat in those recovery bills. I encourage you all, if you are having a situation with a tenant with non-payment, to actually read through them. And also keep in mind that as we're doing this, there is also a state moratorium in effect that requires a payment plan that is reasonable to the circumstances of the tenant. So if you have a tenant who has zero income, it's very challenging to come up with a payment plan that's reasonable there.
I got one thing to add from our office's point of view, if there's time.
Yeah, please, David.
Perfect. So the Fair Chance Housing Ordinance also has recently been amended to protect against what's called COVID-19 related eviction history. So what that requires is that any eviction that occurs within 6 months after the emergency is declared over, the civil emergency that Dulcie brought up earlier, you would not be able to take an adverse action against a tenant because of this COVID-related eviction history. So let's say 2 months after the emergency is over, a tenant is evicted. A tenant applies somewhere else. Let's say they apply at another unit within Seattle. They apply at your unit within Seattle. You would not be able to use that eviction as an adverse to take an adverse action against them, such as denying them tenancy, if that eviction occurred within 6 months after, during the state of emergency, or 6 months after the emergency is ended. So that's just something to make note of, that is considered something you cannot use against someone for future rentals within the city of Seattle specifically.
I don't know why I'm causing all this noise, because when I don't hear any feedback when you guys come on together or otherwise, so it must be me. I'm sorry. I don't know what I'm doing to cause feedback. But that brings us to the end of our slides. I do see some more questions about damage and stuff, so I'm gonna try and answer those. So Nancy says, what if a tenant gets an apartment so dirty that new carpeting, paint, and roaches have to be dealt with? Is that considered damage to the unit? So again, I mean, so dirty, that's going to be a little bit subjective. But if you had a new carpet in there and new paint and no infestation, and you had evidence that the infestation was caused by the tenant in the unit, I would say that maybe rises to the level of damage. It just really depends. But again, ultimately, if there's a dispute about this, it's a judge that will decide. And so it's good to have when you're thinking about this, when you're going into a unit that's been emptied, or if you're the tenant who's leaving, take pictures, document the condition, go through the move-in checklist, and look at the unit through the lens of the checklist, and that should be able to inform what's right and what's the next thing to do. And then there is a question. A tenant has a plant on a windowsill, and the pot leaks over and over. Though the damage happens over time, is this still damage? I would say yes. I mean, if the windowsill was not had no staining on it and no moisture intrusion, and the tenant put the plant on the window and caused the damage that needs to be repaired, then I would say that would probably be damage. I see a question from Mel, who I think was the one that caught my mistake on the holding deposit earlier. Thank you for keeping me honest and correct. What are the rules regarding selling multi-unit buildings? So our department doesn't have any rules. I mean, the only thing that I think you might be referring to, the notice of intent to sell, that is an ordinance that is regulated and enforced by the Office of Housing, and it refers to 2 units or more, buildings with 2 units or more, and only if they're affordable. I'm not an expert on that ordinance because it's not our department's responsibility, but if you go onto the Office of Housing, you'll be able to look up notice of intent to sell. It does not apply to all buildings, but it doesn't apply to single family buildings, for example, and it only applies to affordable units. So go on Office of Housing, seattle.gov Office of Housing, and check that out about that notice of intent to sell. It's just notice requirements. I see that Maureen has answered the question about 14 days versus 21 days because there was a change in that a few years ago. I see, what about if you want to sell the property? I'm not sure what that's referring to.
That was related to the COVID-19 related evictions.
Okay. So, I think I'm beating a dead horse here now at this point. But again, the only reason you can evict a tenant right now is if they're a hazard to health and safety. You can sell your property. There's nothing to prevent you from selling your property, but you can't tell the tenant to move out in order to do that. So you can sell the property with the tenant in it. That may not be ideal, but you can still do that. And you don't have to give notice if you're selling your property and not removing the tenant. The notice responsibility would be on the new owner to let the tenant know that they were the new owner and where the payments would need to be made, and where they would need to contact somebody for repairs or for anything pertaining to the property. I hope that's clear for everybody. You can sell your property, you just can't remove the tenant to do it under the current moratorium. All right, well, next slide is just some final thoughts. We always advise people, both landlords and tenants that we're talking with on a daily basis, Try to consider how you would feel as the other party given the situation and respond accordingly. I mean, that will always help give you some perspective, how you would like to be treated, how you would like to how you would like to engage with somebody. And then when in doubt, please call our helpline, because we are here to help you Monday through Friday, business hours. And we're there for both landlords and tenants. You can also visit our website at www.seattle.gov/renting in Seattle. That has all of the information that you need to know and is updated on a regular basis. It walks both landlords and tenants through the process from beginning to advertise your unit all the way to when somebody moves out and everything that happens in between. So we hear that it's a really good, informative, and not too dense content to get through. We're trying to keep it sort of simple and enough that you know what you need to know, but that you're not overloaded with information, because we are, as a people, as a community, we are overloaded with information all the time. So we're trying to keep it simple. And then we also have a new renter's handbook that we've just published. It's been a couple of years in the making. It's going to replace that information for tenants that is required to be given anytime a renter applies to rent or signs a lease agreement or renews a lease agreement, or anytime the regulations in it changes, a new copy would have to be given to a tenant. So that's a requirement that's already there. This is just a handbook that's replacing the very outdated document that we did have. And it's much more relevant to the actual issues that come up and the things that both landlords and tenants need to know around renting. And it's sort of a companion to the website. It walks you from it walks you through the 360 degrees of renting from beginning to end. So please check it out, and we always welcome feedback. We hope you got something out of this home fair today, and please follow up with any questions that might come up after the home fair is over. We're here for you. We want to give you information, and we want you to have the correct tools and information to be successful. And we have some time left over for more questions if there are any.
So there are a few more in the chat. Is it legal to require a specific range of credit score as one of the requirements for a rental? So generally speaking, there isn't a prohibition on what your rental criteria needs to be, as long as that rental criteria is equally applied to everyone who is trying to rent your property. So you could decide as the owner that you want someone with a credit score of 750, and that's your minimum that you'll accept. You also have to make sure that you're notifying people of what your criteria is in writing before they apply for the unit, so that your possible applicants can make an educated decision on whether or not it's worth it for them to apply. If they don't think they're going to meet the criteria, it might not be worth paying that application fee if they know they won't qualify based on the criteria that you've put forward.
I just want to add that we obviously couldn't cover what generally is a 3-hour training on sort of the comprehensive regulations that apply to renting in Seattle. And even a 3-hour training won't cover everything. So we had to try and condense it down today and not make it too heavy for you guys. You know, these are the most important things, or the things that sort of come up the most, but there's a lot more to know, especially around advertising rental units. There's a lot of fair housing protections around there. You have to be careful that you're not saying something that's potentially discriminatory. You know, for example, I mean, David could give you lots of examples, but I'm off the top of my head, I'm thinking, you know, would suit couple, that could be seen as discriminatory if it's excluding people with children or single people. So there are a lot of rules and regulations, and really landlords need to consider, especially the smaller landlords, need to really consider the business of landlording a business and respect it as such, and really know what the rules and regulations are for their own success and for their protecting their asset. It's really important to know.
Okay, we did have one other question from Chris, and this wasn't touched on in the presentation, but has licensing property managers similar to real estate agents been talked about in the city or the state? There are so many unknowledgeable property managers that I'd like to see the possibility of this discussed. So part question, part comment. Thanks, Chris. Off the top of my head, I don't know that the city has had conversations about licensing property managers. I think making sure that people coming into any type of position that is so governed by ordinances and code and just generally how to deal with different kinds of people, that having a good standardized training for those folks is a good business practice. Personally, I don't know if the city has had conversations around this. I'm relatively new to the city, so I would open that up to my colleagues that are also on this webinar.
I have never heard anything about licensing property managers. The Office for Civil Rights and our department, especially since we started training together, we offer certificates to people who do the training, because it is quite a comprehensive training. And I do think people should be doing it regularly, because I can tell you that even because I have not been doing live presentations of this material in 2020, I've had to go back and remind myself about what are in the codes and what are the specific rules and provisions. There's lots of nuances. So it's something that people should be doing regularly, is attending our free presentations that we do. We do landlord workshops. We were hoping to do 6 of those in 2020, and then of course COVID happened. We have prepared an online resource that you can find on Seattle.gov, Renting in Seattle. On the resource page for landlords, there is a recording of a webinar we did in 2020, but we should be trying to do some more webinars soon, and hopefully sooner rather than later we'll be going back to actual presentations instead of virtual presentations. And I just want to say, I'm sorry, David, I just want to say before I unmute myself again, that I am currently checking that link. I copied it directly from the source, but I don't know what happened, but I am going to get to the bottom of it. So that's what I'm going to do right now. If David wants to chime in, or Maureen, thanks.
Perfect. What I was just going to say is the link that Maureen posted in the chat. If you want to look at that at some point, there's a lot of resources there, and the training that Dulcie talked about would also be there, where it covers all the topics we talked today generally, but it goes into a lot further detail. It covers a lot of things we didn't actually cover today. So if you would like a full overview about the things we're talking about today and more information, I would check that out if you have the time.
Were there any questions from the chat that we may have missed?
I think there is actually one that was typed multiple times that we didn't address. It's about Airbnbs and long-term rentals, 30-plus day rentals. How are those regulated? Do they fall under these same things they're asking, I believe?
So short-term rentals have a different regulation structure. There's also licensing that goes along with Airbnbs and transient housing accommodations like hotels and motels. However, if you have someone who is staying there for 30 days or more, those individuals are generally considered tenants and will have the protections of the just cause eviction ordinance. And I can post a link to our information on Airbnbs right into the chat for the person who was asking that question and for anyone else in the group who may be interested.
A couple other questions that I see here too. What was the name of the agency you said was the largest landlord advocacy agency?
Oh, that's the Rental Housing Association. I think we can put a link up to that. We work closely with them, and also the Multifamily Association, which also represents landlords. But in the city of Seattle, I think Rental Housing Association is predominantly who landlords use.
Perfect. And I think the last question I keep seeing pop up too is also, are there any special regulations on renting by room? So I assume that's renting out a single room and maybe a home.
I think we might need a little more information on that question to be able to give a really concise response. Any clarifications on that question? Special regulations regarding what? There are some exceptions in the code. I'll say this just very generally for properties that are owner occupied. So if their owner is renting out rooms in their single family home and the owner is also occupying that premises as their primary residence, there are exceptions built into different parts of the code. One of those areas is with respect to the move-in costs. There are exemptions for single family owner occupied units in that particular section of the code. So you just want to make sure that if that's your circumstance, that the particular regulation that you're looking at is not something that you would be excluded from because you are an owner occupied property.
And another question I see actually come up a couple times also here is, are there any COVID showing protocols? As in, I interpret that as, are there any special protocols in terms of showing a unit right now because of COVID?
So what I would say is keep informed with the different phases of reopening. So for example, in one of the phases of Governor Inslee's reopening, real estate showings are prohibited, but you really need to check on the state's website for what the specifications are around that. For our purposes, the general information that we're providing to people, both owners and tenants that call with this question, is you still are required to give the notice, right? So if you're entering a unit for any reason, you want to give that 48-hour notice. If you are showing to sell the property, you would want to give the 24-hour notice. But we're also really encouraging people to use common sense in these circumstances. If there is not an urgent reason that you have to enter someone else's household, please keep that in mind, that, you know, right now, even just having people within your household or having groups that are larger than 5 can be a health risk. So unless there is a need to physically be in the property, think about what alternatives you might have to doing that, like a virtual showing. We are telling people they have to follow all the CDC requirements and the King County Health Department's requirements as far as coming into contact and how many people can be in a space at a time, and wearing proper masks and gloves when entering a property. So it goes back to, I think, some of that very common sense advice that Dulcie gave towards the end of the slides, which is, if you were in a situation, if you were someone who is potentially high risk for COVID and there wasn't something urgent happening in your unit, meaning, you know, there's no urgent repair that needs to be made, and you can accommodate the landlord by helping them with a virtual walkthrough if they're showing the property, you know, would you want someone or several people coming in and out? You might also want to keep in mind that for tenants that are high risk, they might be entitled to a reasonable accommodation if you give them a notice of entry.
We got another question come in. Can you touch on what happens when a 12-month lease expires and it clearly states that it doesn't convert to month? Can the landlord ask the tenant to leave? what are restrictions on raising the rent at that point?
You cannot ask them to leave or raise the rent while the eviction moratorium is in place. Any other questions?
Um, what was I going to say? I was going to say I just sent a link to. I hand typed the link that I was given. I'm hoping that will work for folks. Can somebody try that link to the renter's handbook and see if it's bringing up the new handbook? Great. Thanks, Eleni. Thanks. Well, we're going to be here. We're going to be here for another 15 minutes. So please continue to ask questions if you'd like. We're so glad you came today. Thank you. It'd be much better to meet you in person, but hopefully that will happen this year, maybe next, that we can be out in the community and engaging with you guys directly and without masks. That would be nice. That's the hope. But thank you so much for participating today. We really appreciate you. And I just want to give a special shout out to any small landlords who are really trying to do the right thing right now and who are under immense pressure because they may not be getting the rent that they need to pay their mortgage on their investment property. We know that you're struggling and we want to help you as much as we can. I wish there was more help. But stay clued in to our website and to the resource page, because anytime there's new funding or help with rent assistance, and there was prior to the end of 2020 for small landlords and tenants to apply for rent assistance. Hopefully there will be more funds forthcoming, and that's where to find the most up-to-date information.
A couple more questions, I guess, since we have time. So just to reiterate, quote, once the moratorium is over, we have tenants that have not paid rent. We have to provide them 14-day notices, payment plan options, and other notices. Is there anything else we should know about so we can recoup the rent that hasn't been paid?
Maureen, could you possibly speak to that? Oh, you were just about to. I'm going to unmute. I'm going to mute myself.
Yeah, I think one of the things that has been coming up where there's confusion. So yes, essentially, if you have a tenant who has not been paying rent and over the course of the moratorium, and you haven't been issuing those 14-day notices because they're not permitted while the moratoriums are in place, when the moratoriums lift and you issue that 14-day notice, you want to make sure that it has the additional required language that was added to the code. So again, the added language about it being a defense to an eviction if the debt is COVID related. And that is a new section that was added to the just cause eviction ordinance. It's new section 9. And then there's a standalone ordinance for installment payment plans. And you want to make sure that you're documenting all of your attempts to engage with your tenant about the payment plan option, because you will need to be able to demonstrate that. The other thing I would say is there's a lot of confusion around late fees. Late fees cannot be charged for any of the debt that was accrued during the time frame of the civil emergency. So it's not that it can't be charged right in this moment, it's that you can't accumulate it and then add it into the tenant's debt after the moratorium expires. It can't be accruing during this time, and there seems to be some confusion around that. Chris, did that answer your question fully?
We also have a question if this is being recorded, that someone came a little late and would like to listen and watch the part they missed.
Yes, this is being recorded, and I will actually repost the link that has access to this. I am not certain that it will be posted right away because, as Dulcie mentioned at the beginning of the presentation, the home fair spans 2 weeks. So it's this weekend and next weekend. I don't know if they're going to post these presentations as they go, or if they're going to wait and accumulate them all together and then post them as one big event. So it will be available. You might have to check back a couple times for when it is posted though. And I'll put that link in the chat one more time.
And Chris stated you did answer Chris's question.
I just saw a question from Mel. I think that's the second time he's asked. It's a question about small claims court and collections. That's not really our area, Mel. You'd need to probably talk to the court. There's probably a statute of limitations as to how long after a court decision or an award that you can go collect it. And I'm not aware of what that is. I don't know if Maureen, off the top of your head, if you know if there's a certain amount of time you have to pursue a debt awarded in small claims court and collections. Do you happen to know that, just by the by?
Not affirmatively off the top of my head, so I don't want to put the wrong information out there. But what I will do, Mel, is I'm going to drop a link to Washington law help information for debt collection. If I'm remembering correctly, part of the question earlier was about, can you be engaging in debt collection during COVID, even if it's against someone who is not a current tenant. So it's someone who's moved out before the pandemic hit and you have this award, can you be doing things like trying to garnish their wages or send them to a collection agency for that? I will say before you do that, you want to check the state's regulations around debt collection, because there were protections put in place for people who were subject to garnishments and other type of collection actions. It's just not our area of expertise, so I don't want to steer you the wrong way, but I do want to caution you that there probably is some restriction on what you can do right now.
And in terms of Sue's question, are we automatically signed up for next weekend by attending this Saturday? I think you would need to follow up with wherever you registered for this, because I don't think we have the answer for that specifically. As we're just leading these specific presentations, you may need to follow up with wherever you registered for this event specifically.
I think it's time to wrap this up. Thanks for staying with us throughout, and please stay in touch via our website or our helpline, and also the listserv. I hope you're all on the Renting in Seattle listserv. You should be getting emails about any legislative changes or any new resources or any COVID updates. If you're not a member of the listserv, then please email me and I will make sure that you get added. I'm going to send my personal email here. And if you're not receiving those listserv mailings by email, then sign up. All right, well, it doesn't look like we have any more questions, so just thanks so much. Any last comments or thoughts, Maureen, David?
Just thank you all for being here today. Thank you for having a great conversation with us by participating in the chat, and we look forward to meeting you all in the future, potentially at future trainings.
Thank you to everyone. I just want to reiterate Dulcie's earlier comment about our struggling small landlords. See you, we hear you. We're all hoping that we're out of this really soon, and we appreciate the support that you're providing to the community right now. And when we have resources available, we will let you know either via the listserv or postings on renting in Seattle to keep everyone up to date. And until we get out of this, please stay safe, please stay healthy, and thanks so much for joining us today.
Thanks, everybody. Follow up with us on the helpline if you have anything else that you need to know. Thanks so much. Bye.